Yay!
So we're seeking motion to approve the public comment.
Yes, that's all.
Muzzle the public.
Recording. That's not it. It's for everybody. It's for everybody. It doesn't feel chilly. It got a little bit warmer. A little bit?
No, not really. It's set at 65 or 7.
God.
You're probably not bad at it.
All right, let's go. Yeah, right. Okay. The Plainfield Township Park District reconvene at 7:05. Action items. Do I have a motion to approve the proposed public comment policy included in the executive director's memo? Do you have a motion?
I'll make that motion.
Do I have a second? Do I have a second?
Hold on a second. Sometimes I can't hear the way
Do I have a
this
second?
is set up. Yes, yes.
All right, discussion. Hearing none? Roll
No,
call?
I,
Oh, okay, sorry.
Our board manual already addresses public comment on pages 20 and 21, and I'm uncomfortable with points 2, 3, 4, 5, and 8 in the proposed. 1, 6, and 7 I can understand, but some of these other ones can be too subjective, where one person might not like something someone's saying, and another person might not think it's so bad, and vice versa. And when we start trying to judge stuff, I think we can kind of get into a bad position.
All right, let's discuss one item by item. Do you want to talk about number 2?
All speakers shall address their comments to the chairperson. The chairperson may request that the appropriate member of the park staff follow up with
With a
concern
possible response.
and a
All
possible
right.
response.
You have a problem with that?
Just that, maybe that one wasn't so bad, but I was just looking at the rest of these.
So
Because that
number,
one we've been
let's go,
doing.
it's the best of Mary, so,
Okay.
so we can,
Because number 1, I understand, 3
all right,
minutes.
so number 3,
3,
the chairperson shall preserve order in the current.
and decide all questions of order, because that's where it gets a little subjective.
Well, that's according to the rule of order. So it's basically, that's where it came from. Number 4,
When addressing the park board, persons permitted to speak shall confine their remarks to the matter at hand and avoid personal remarks, the impugning of motives, and merely contentious statements. If any person indulges in such remarks or otherwise engages in conduct injurious to the harmony of the park board in the meeting, the chairperson may immediately terminate the opportunity to speak. And then it goes on to say this decision is at the discretion of the chairperson or upon the affirmative vote of 2/3 of the park board commissioners present. Any person who engages in disorderly conduct during a meeting may be ejected from the meeting upon direction of the meeting chairman. It just seems, we've never had issues in the past where we needed to have such a heavy-handed policy. More recently, you've had issues, but
Right,
as a
but-
park district,
Mhm.
I just think this is too restrictive on people's freedom of speech?
We're not restricted to the freedom of speech, we're just restricted to the subject at hand and the person's remarks and also the personal attack. I think is, like I said again earlier today,
Well,
is
right, if
when we
someone's
have
being
the,
obscene, that's
board
one
annual
thing.
policy, when I wanted to do the changes earlier when I joined the board, but now things have changed. So now you guys want to change that stuff. I think this is a good policy for now and beyond what I'm saying is after I leave the park board and whenever somebody else takes over. There's some policies to look at something to be proactive for the future.
So a point of clarification for the board, this would update our policy in the board manual. In addition, this is probably 98% of what Bolingbrook Park District uses. This is actually where I derive the majority of the language. A little bit of it is tweaked, but this is essentially how Bolingbrook Park District runs their meetings. I do think Bolingbrook's a well-run park district.
Yeah, thank you. Any other, number 5? Should be okay, right?
5 is okay. It's
Number
just
6?
6, let's see.
Any member of the public may address the board in public comments and public hearing regardless of.
That one was okay.
Okay.
And 7 was okay.
Number 8?
Comments from the audience outside the confines of public comments are not permitted, loud noise, distraction. Again, I just thought, again, this would be too subjective. If somebody accidentally forgets to put their phone on silent mode, are we gonna throw them out of the meeting?
Well,
It's just a little too,
I understand what
stuff like that is common knowledge and courtesy.
Yeah, I think what that would be up to the chairperson to decide, and I'm assuming is, we cannot just say, your phone call went off, you gotta leave. I think we have to be more meaning of what we do. So, I'm perfectly fine with this policy.
That's all I
All right, thank you. Any other
Any
comments?
comment?
Yes, sir.
Yeah,
Excuse me.
we had a meeting this past summer, and I agreed to a certain extent on certain things that I felt were too restrictive. But we had some events happen ever since I've been on the board. I mean, things that would never have happened before. The board presidents in Latino accent has been mimicked, made fun of in meetings, and I know who did it, but I cannot say. The words fascist yelled out in meetings, things that never would happen. And so it puts us in an awkward position here where, you want people to speak up about the issues. This is what the Open Meetings Act is about. It's about the park district. If you have something, concerns, et cetera, et cetera, et cetera. But the personal direction that comments have taken, it also takes us off track. And if I was to, I was going through the board manual. It tells me how I should speak and what I should say. And going through there, it really, how board members are supposed to speak and what they are supposed to say. And I think that we are a board of elected but voluntary, and we are doing the best we can for the park district. And we live in this community, and we would appreciate, we would like to have the commentary from those people who are concerned about the park district as well, who have come to these meetings and also reflect that.
Thank you. Any other comments? Discussion, sorry. All right, hearing none, roll call, please.
Steinings?
Here.
Ludeman?
No.
Newton?
No.
Solosky?
Yes.
Furtado?
Yes.
Motion carries.
Yeah,
Someone wishing to speak.
yeah, Wanda, could you please read the public comments policy, because the public comments are coming up,
Oh,
so
sure.
everybody's aware of what the rules are.
Sure. A person shall be permitted to speak upon being recognized by the chairperson. Please stand if possible. Announce your name and address before commencing. All comments under public comments are limited to 3 minutes, and each person shall only be permitted to speak once. All speakers shall address their comments to the chairperson. The chairperson may request that the appropriate member of the park staff follow up with the concern and follow up with a possible response. The chairperson shall preserve order and decorum. The chairperson shall decide all questions of order. When addressing the park board, persons permitted to speak shall confine their remarks to the matter at hand and avoid personal remarks, the impugning of motives, and merely contentious statements. If any person indulges in such remarks or otherwise engages in conduct injurious to the harmony of the park board and the meeting, the chairperson may immediately terminate the opportunity to speak. This decision is at the discretion of the chairperson or upon the affirmative vote of 2/3 of the park board commissioners present. Any person who engages in disorderly conduct during a meeting may be ejected from the meeting upon direction of the meeting chairman. Comments should not be repetitive. Any member of the public may address the board in public comments and public hearings regardless of residency. Each meeting agenda will have a designated public comment section provided. This is the only time comments from the public are allowed unless called upon by the chairman or during a public hearing. Comments from the audience outside the confines of the public comment section public hearing are not permitted. Loud noises, distractions, and other overt disturbances from the audience used to interfere with the public meeting will not be tolerated. The chairman of the meeting has full authority to deem a member of the public a disturbance and eject them from the meeting room at any time. Cellular phones, laptops, handheld computers, and related items must remain on silent or vibrate.
Thank you, Lynn.
You're welcome.
All right, action item B, do I have a motion to allow a special use permit to facility rentals at the Heritage Professional Center? Do I have a motion?
I'll make that motion.
Do I have a second?
I'll second.
Discussions.
The big question is, why does the village require a special use permit for this use?
The village contacted us at the Park District and had mentioned they were made aware that there was a religious assembly taking place in one of our subleases. I corrected them and said, no, it's a room rental. It's not a written sublease. It's an ongoing room rental that Cheryl has worked out with this pastor with God is Able Church, a very nice gentleman. And essentially, they are required under the village code, according to Brian Murphy, our village administrator, to have a special use permit, which they do not.
Well, I'm asking what the justification for that is, because it doesn't make sense that they would be required to get a special use permit to assemble in a Park District building like that.
For religious
For
assembly.
any purpose.
If I may, it's based on the zoning of the village. It's zoned to B5 property, and based on the zoning, any building that's zoned to B5 is required if there's religious assembly to have a special use permit.
And I think previous to the Park District leasing the property in the basement, the landlord did have a different church, I believe a Baptist church there, that did require a special use permit, and they did have it. So our recommendation is that the board pass a policy that no longer will we lease rooms to tenants that need special use permits, but grandfather this church in since they've been with us, and we don't want to necessarily kick them out and put them out in the cold, but we do want to, honor what we've, been offering for this church, but also not have to go through this in the future.
What would be the problem of going through this in the future, now that we know?
Well, it's a little convoluted, who's going to pay for the special use permit. It can be costly. It also requires any Park District staff member typically to be at the village meeting to answer any questions. Cheryl and I, at a staff level, recommend not moving forward with having other tenants in the future with a special use permit.
Because we could make that part of their rent, and I'm not sure how the village does things, but a church use, I would think, would have to pay a fee.
They would have to pay a fee for the use permit. You'd have to have an attorney
A
typically.
tax exempt church would have to pay the fees. They don't have
We'd have to-
exemption for that?
We'd have to ask, for a permit, we'd have to ask the village that question.
You would think
Their
they did.
staff, at a staff level, they could answer that. I mean, I can find out for you if you'd like and follow up.
Okay.
But since we didn't have a December meeting, I got the village to extend the courtesy to allow them to stay there without a special use until we had our meeting this month and get this settled and figured out. But I do need a policy. And if the board decides that you want tenants with special use permits and for staff to deal with that, I mean, that's up to you, but we recommend not having tenants that require special use permit.
Well, my suggestion is that the applicant themselves, if they need a special permit, then they were the ones that can obtain it on our behalf. I don't think the park district is necessarily, should necessarily be required to obtain a special use permit, but I don't see any reason why we wouldn't want to allow this use on a Sunday morning at a facility that's remaining vacant that we're leasing. So I don't necessarily agree with the policy as written, just that it should be the tenant's responsibility to obtain the special use permit if that's what's required.
The board, if we want to modify the policy now, Matt, can we actually do an amendment to the motion as far as the policy goes to, if the board decides to go in a different direction, as Commissioner Newton has suggested?
You can withdraw the motion.
Withdraw the motion and then add those stipulations. So essentially, the other, commissioners that consider is do we go with what staff has recommended or Commissioner Newton's proposal?
I think we should go with the staff's recommendations. I think it's definitely the way to go in regards to that. And that's all I have to say.
Commissioner Stein, Salaski?
I'm interested in what Mr. Newton, Commissioner Newton has to say on this. I think we should.
You're interested in allowing special use for the tenant?
At what cost?
Well, that would be up to us and to you, if you want to have it that the park district does not get involved in the process of obtaining a special use permit, and they have to get it ahead of time before they come to us for a room rental. You can add that stipulation if you like. That's up to you.
No.
So,
To bring back to legalities in regards to that, is that legal?
is it legal? I don't see why it wouldn't be legal.
Sure. I mean, what you would do is you would have as an element of the lease that they would have to provide proof that they have gotten a special use permit prior to signing the lease, just like you do with.
Is it about part of a sublease contract agreement?
I'm sorry?
Like a sublease?
It's a room rental.
It's a
Yeah, it's a room rental. So
It's not a
again,
lease.
it's, presumably they provide certificates of insurance, correct? That kind of thing? Okay, so they would do that prior to any, just like they would, so if they do require a special use permit, then they would have to provide that prior to signing the lease, if they do require it. And then the cost would be borne by them, is what it sounds like. Yeah, like I said, basically, I don't understand why the village is going after this church in regards to our facility being used by Park District in regards to participants, so I don't know, what's the,
The current use requires a special use permit. For any religious assembly requires a special use permit under the zone that building falls within. So in order for them to continue with religious assembly, they would need a special use permit
well, that's basically a gathering of people, basically the
for
church.
religious assembly, correct?
Right. So in regards to stating religion versus preschool assembly, so they're saying they're going to be discriminating towards.
I'm not gonna.
Basically, that's what I'm looking at, in regards to religious faction.
There is a village trustee in the audience that wants to speak, if the chairman wants to recognize him.
Go ahead.
We have, Paul Fay, village trustee, we have issued special use permits for preschools, a number of other uses when it's zone B5 or B2, because those uses are not typically permitted. That's the purpose of a special use.
Thank you, sir.
But at this present time, does the Park District have that permit in regards to, for the use of that heritage facility?
If we're gonna allow the tenant to continue to do the room rental, we're gonna need to get that special use.
Well, it still doesn't answer my question in regards to
If I may-
preschool versus.
If I may, Peter, preschool is not required under the B5 zoning to have a special use permit. And what we have there is preschool and recreational programming.
Well,
Those
what
are,
I'm trying to understand is what's the difference between church,
that's not my
congregation,
call.
and
That-
preschool? Well, maybe the village can answer that question.
I don't think it has anything to do with religion.
So what's the point?
We have zones to accommodate certain businesses, certain residential areas, industrial, and when there is a use that is outside of what it has been zoned, they apply for a special use permit.
Well, in this case here, it's being used for preschool versus
On off days, it's gonna be used for, a church congregation. So tell me, what's the difference between the two?
One's a church, a separate business, for lack of a better word, and one's a preschool.
Well, it's not, a church is not a basic business, it's
I
a
said for
not-for-profit.
lack of a better word.
And so is the park district. So you tell me, what's the difference between the two?
Why is he debating with this individual here? He's a representative of the village of
Excuse me, sir.
Plainfield.
Excuse me, sir.
Excuse me, you know what? You people don't know how to run a meeting. Why don't you conduct it as Mr. Peck?
Sir,
What?
please be quiet. I'm trying to listen what Mr. Fay has to say.
I have nothing further to say.
He has nothing further to say.
Okay.
I thank
I
you,
won't
sir.
engage.
Well, I'm just bringing a point for us that I don't see the difference between the two. Thank you.
All right, thanks. So we have a motion, we have a second. Do you guys want to change the, you want to revert the motion? Commissioner Steiner? How do you vote?
I'd like to stay with the motion I have on the floor.
The motion was to allow special use permits, right, as it's written on the agenda.
Right.
The recommendation, as it stands, rentals requiring additional permits from any other agency would no longer be allowed. If you would like to change that, that is what we are here to the board, for you to decide as to what type of rentals you are willing to allow in that space. Am I clearer on that?
Yeah, and for Commissioner Newton, he had some good suggestions about maybe, just allowing this. What I'm concerned about from a staff level is, as far as enforcement goes, how is the park district staff supposed to know all the village ordinances as far as the zoning and what needs a special use and doesn't? And let's say we have a tenant that's doing an ongoing room rental, then the village calls and says, hey, guess what? They need a special use permit, and we didn't know ahead of time. Even though we have it in our policy that says you need to have this ahead of time, then are we the bad guys, people for evicting them and saying, no, get out, you need to get the special use permit? I think it puts us in a precarious spot with the village that we have a tenant that's not compliant. So that's the thought process behind, staff's recommendation to just not allow it and say that's where it's at. But if the board chooses, we'll go with your direction.
Well, I don't think the Holy Spirit adheres to zoning, so.
The planning department in the village can certainly provide a list of what the zoning entails and what's required for special use. And if there was a tenant that was questionable, we would defer that ultimately to the village to approve or deny that permit, and then that would decide whether or not they could come.
All right, no other discussions? All right, roll call, please.
Which motion are we voting on?
We're voting
On the recommendation?
on. Roll call, please.
Steines?
Yay.
Ludeman?
No.
Newton?
No.
Solosky?
No.
Hurtado?
No.
Motion passed.
Now I'll make a recommendation that we motion to allow for special uses as long as the applicant obtains it prior to signing the rental agreement.
I'll second that.
All right.
And is there any stipulation that then the park district is not responsible for enforcement?
I don't believe that we need to worry about that. I think if the village has an issue, then they can raise it with us.
Okay, thank you.
All right, any other discussions? Hearing none, roll call, please.
Steines? Ludeman?
Yes.
Newton?
Yes.
Solosky?
Yes.
Hurtado?
Yes.
Motion carries.
And then, public comments. This is time for you, the public, to speak. Yes, sir.
Good evening, everybody. My name is Pastor Richard Wright. I'm the pastor of God is Able Christian Church, the church that you just was discussing. We came out of this community from Richmond Park to be a positive force in this community. I am the father of 4 kids here who are all members of my church. My church probably consists of about 15 people at this time. We have had a great relationship with the Park District since July 2012. We share our equipment. This podium right here is our podium. The other podium is our podium. The chairs that are used at the meetings when you're over there or any rentals are our chairs. The drums are used for drum lessons that the park district has. We allow our drums to be used. So we're very, very much integral in terms of this community. I am a professor at Rasmussen College. I am a retired lawyer. I gave up law in 2000 to serve God because I believe that the Holy Spirit was inerrant, and I still believe that. And so I am happy that we'll have an opportunity to be able to continue our relationship with the park district until we grow bigger. And when we do grow bigger, we hope that the park district will be able to come to our bigger location that we come to. We will continue to do everything that's possible to make this community proud of having God is Able Christian Church as a tenant in the Heritage Professional Building. Thank you.
I'm gonna buy the first pulpit for you, Pastor. I'll get your name after.
Hi, I'm Marion Judar. I'm Executive Director and Community Lawyer at the Citizen Advocacy Center in Elmhurst. And I'm here tonight to address the board about the public comment policy that you all just passed. You just passed a public comment policy with many legally indefensible provisions. This is textbook First Amendment. You've got objective criteria and you've got subjective criteria. The objective criteria, that's okay. Confining people to 3 minutes, that's excellent, legally defensible. Asking people to announce their name and address, that's excellent, legally defensible. Designating a public comment at each meeting agenda, even after you make some decisions and you don't allow the people to speak beforehand, that's acceptable. And those are objective criteria that you can apply even-handedly. However, there's a lot of provisions that you can't apply even-handedly. They're subjective. The U.S. Supreme Court has said you can't, in a government facility in which a forum has been opened for the public to comment on political matters, you can't confine their remarks to the matter at hand. What does that even mean? Who's going to be the arbiter of that? President Hurtado is going to be the arbiter of the matter, what the matter at hand is? Avoiding personal remarks and the impugning of motives and merely contentious statements. Contentious means of or concerning controversy. How many people do you think are going to come up here and give you public comment about controversy? I mean, what are the chances of that happening? 100%? That people are going to come up here and say things that are contentious in nature, and you're going to ask them to sit down? You're the arbiter of this? And you know what? These kinds of provisions are used to silence people who dissent against the political majority, and they're used to silence people that you just disagree with. It's called viewpoint discrimination. That is 100% not allowed under the First Amendment. And you're paying attorneys, like 4 attorneys to look over an investment policy? Ask your attorney here to look over this policy. What case law supports this policy as being constitutional? I ask you. Why don't you ask some of those other attorneys that you hired for that investment policy that you guys asked to have them look at? You know, I can suggest them to you. I went to a local government law institute training by ICLE, the Illinois Institute for Continuing Legal Education. Holland and Knight, Kirkland and Ellis. Law firms, attorneys from these prestigious law firms speaking to a room full of public officials and people who work for government bodies saying, these kinds of provisions are not constitutional. You all just passed. Where's your oath of office of like, you know, I'm going to promise that I'm going to uphold the U.S. Constitution? I don't understand what you people are doing. You are trying to silence your critics. You are trying to chill your critics by having these officers sit here so that you can ask people to be removed willy-nilly. Jim isn't removed when he speaks out loud, but Vicky is removed when she speaks out loud in the meeting. That's not putting even-handed rules in place. This is really, really unprofessional behavior. And you want to talk about decorum, rules of decorum? How about playing tic-tac-toe during a meeting? How about the public official, elected public official in a government employee playing tic-tac-toe on camera in front of a room full of Plainfield residents, people who care about Plainfield Park District, and a bunch of students. Oh, I love your smile, President Hurtado. Excellent job. You're doing a wonderful job.
Any other?
No, you're up first.